Okay, good evening, everyone. I hope I am audible and visible to all of you. Now, as we know that the President of India and the Vice President of India, new President and Vice President of India has been elected in our country, it is important for us to know everything. So, how the President of India is appointed, what is the eligibility criteria, when they can be removed from their office, what are their functions, what is the pardoning power of the President. So, we will just go through all these things in the next whatever time it will be taking. Just we will be having a general idea so that if we are getting any question in the legal passages or even in current affair, we are having a thorough idea about everything. So this might be asked even in your legal passages, and current affair you have high probability of getting a passage in president and vice president either on separately or a merged passage. Okay, so just I would request you to sit with a notebook and a pen so that you can just write in short, just in short word keywords, that whatever areas you have to remember. For example, it is something for the tenure, something for the article that you have to remember, because it is important for your current affairs section from that perspective. And even in the legal passages you might get a passage based on the president and vice president, any of the thing. So let's start with the first thing, the first slide. Now, when we talk about the President of India, so this is very from the basic of class 6, 7, we know this, that the President is the first citizen of India and he is the head of the state. Okay. However, we know that the President is just a nominal head of the country and not the executive. He is just the executive head, the nominal head. The real power is vested with the Prime Minister and the Council of Ministers. So it is not the President who is the real head, he is just a nominal head. What is the meaning of the term nominal head? Why he is not the real head? Because the power actually rests with the Prime Minister and Council of Minister according to Article 74 of the Constitution. So whatever decision is taken by the Prime Minister, Council of Minister, the President is duty bound to abide by that particular decision. So if tomorrow, if you saw that citizenship amendment bill, triple talaq was there, in all these circumstances, when the bill was presented, when the bill was presented to the president is bound to accept that bill in any circumstances. So the president of India is regarded just as the nominal head and not the not the real head. He is just the nominal head of the country and not the real head. Where the prime minister and the council of minister is the real head. Okay, so the president is regarded as the first citizen of India and he is the real head. When we talk about the parliament consists of the Lok Sabha, Rajya Sabha, and the president. Okay, so if you are noting, just write it in a short key that the parliament consists of the Lok Sabha, Rajya Sabha, and the president. So Lok Sabha we have all the MPs, Rajya Sabha we have MPs and nominated member, and then the president. This entirely comprises of the president of India. So Article 52 to 78 of the Indian Constitution deals with the executive power of the president, in which Article 52 to 62 specifically talks about the president. So you don't have to remember the range of the article, you just have to remember from this slide that he is the first citizen of India, he is the nominal head of the president of the country and the head of the state. Okay, next slide. So it is very clearly mentioned in the Article 52 that there will be a president of India and every executive power will be vested in the president. So it is the every decision that is taken in the Union of India goes through the president, because every bill, whether it is the citizenship amendment bill, data protection bill, or the triple talaq bill, it has to be signed by the president. Now here you have to remember that every decision of the prime minister and council of minister, the president is bound to accept. The maximum he can do is to return the bill for once. That we will be, when we will be moving forward with the slides, we will come to know that only once, the maximum time the president can send back the bill for reconsideration to the Lok Sabha, Rajya Sabha is once, after which he has to accept it. So every power of the executive is taken in the name of the president. If you have seen any of the official gadget, or if you remember when the triple talaq ordinance was brought, the president of India do here solemnly recognize that the citizenship amendment bill will come into force on 9th of August 2022. So every decision of the executive is taken in the name of the president. He is the head of the state, but the decision of the prime minister and council of minister is bound on the president. So the executive power is vested with the president, and every decision, if you see the official gadget notification of the government of India, everywhere it is the president and not the prime minister. So that is the thing, that Article 52 states that there shall be a President of India. This is a very common question that you might get when you are having a current affair passage on this, because the election of President and Vice President is not a very small thing in a country like India. We are having a democratic country, indirect election happen, legislative assembly, Lok Sabha, Rajya Sabha, everyone votes. So it is a very important topic for current affair, even for the legal passage, guys. So this is very important article that you must remember, that Article 52 of the Indian Constitution states that there shall be a President of India and every executive power is vested with the President. You don't have to remember Article 53. Next slide. Now this is very important that you have to understand. You might get a question on this, on the legal passages also, then you have to solve it accordingly. The President of India, this is very clear. All of us know from the very, we have studied in the civics of class 7 and 8 that the President of India is not directly elected. Who is directly elected? Our Prime Minister. So if you remember the 2019 general election, we are going to have the general election in 2024. Similarly, every state legislative assembly have their general election. If you remember, just half an hour or 1 hour before, there is a political turmoil in Bihar. So there is a split in the JDU and BJP, the NDA has split and they are going to form another government. Now, Chirag Paswan, if you know the name, Chirag Paswan is demanding that there should be fresh election. It is not easy to organize fresh election. He is demanding that there should be president rule in the Bihar and then a fresh election should be conducted. Generally, we have fresh election after every 5 years. So whether it is legislative assembly or whether it is the Lok Sabha, we have the election after every 5 years. That is the general election we call. So we had in 2019, we will be having in 2024. What Chirag Paswan is demanding, that is called a by-election, okay, or mid-term election. So if today president rule is imposed in the state of Bihar on the ground of breakdown of constitutional machinery, then there will be fresh election after 6 months. That will be called the mid-term election or by-election. So that is a direct election. So tomorrow Ankit will be more than 18 years of age or Kinjla will be more than above 18. So she will be having a voter card. You all will be having a voter card. You will directly go and vote to the whichever candidate you want to see as your prime minister or your CM. But when it comes to the election of the president, it is an indirect election. Why it is indirect election? Because if you remember, we as a citizen of India do not vote for the president of India. So it is our MPs, our MLAs whom we have already who are already representing us. They will be electing the president of India. How it is done? This is the electoral college that you have to remember, guys. That for the election of the president, there is an electoral college consisting of the elected members of both house of the parliament and elected members of the legislative assembly. And in this article, and Article 55, state include National Capital Territory of Delhi and Union Territory of Pondicherry. What is important? I went through a passage of, I don't remember the name of the coaching. The question was on the election of the president, which had recently been held in India. Now, the options were, the question number 2 was something like this, that which of the following is true about the electoral college? Or it was something like this, that what does the electoral college of the president consist of? Option A, elected member of both houses of the parliament. Option B, elected members of legislative assembly of the state. Option C, nominated member and elected member of house of parliament, nominated member of legislative assembly, or an option E, both A and B. Very clearly remember that it is only and only the elected member of the Lok Sabha, Rajya Sabha and the legislative assembly who consist of the electoral college of the president. Okay, not the nominated member. So we have 12 nominated member in Rajya Sabha and 2 nominated member in Lok Sabha. Am I correct? Ankit, Kinjla. 12 nominated member to Rajya Sabha and 2 nominated member to Lok Sabha. Do we have still? 2 in the Lok Sabha, not anymore. Okay, very good. We don't have the 2 in the Lok Sabha. We have only 12 in the Rajya Sabha. So this nominated member will not be voting for the election of the president, that is the electoral college. So you have to remember the electoral college consists of the elected member of both house of the parliament, that is Lok Sabha, Rajya Sabha, the elected member of the legislative assembly, and here the state includes Delhi and Pondicherry. So not Chandigarh or not any of the union territory votes for the president election. It is only Delhi and Pondicherry which is included in the state part. So this is the electoral college which votes for the president of India, and it is an indirect election. This is very important that you have to remember. Next. So I have kept it 6 to 8 p.m. It will not be a long session, don't worry. I have kept it so that if it is extended, that we have the time. If I would have kept only 7, we could not extend the session. We could not go into much depth. But it will not be a long session of till 8 p.m. We will keep it short. But we have to cover everything. We have to just glance through everything so that tomorrow we have knowledge if it comes in any of the section. Now the vote of an MLA. So how the vote of an MLA is calculated? The vote of the MLA is calculated is the total population of the state. So whatever is the total population of the state divided by the total number of elected members in the state legislative assembly into 1000, 1 by 1000. Yes. So whatever is the total population divided by the number of, so if it is Uttar Pradesh, so whatever is the number of the elected members in the state legislative assembly, not in the parliament, in the state legislative assembly into 1 by 100. This is the calculation of the vote for an MLA. When it comes to the MP, it will be the total value of votes of all MLAs of all state. Now you must be thinking कि यहाँ लिखा हुआ है total values of votes of all MLAs of all state. How do we know this? So it's already on the Election Commission website. Okay, if you go to the Election Commission website, you will find that the vote of every MLA of all the state has been already been given there. So according to the MLA, according to the population, the vote has been already calculated. For UP it is 243, for West Bengal it is something. No, just for your knowledge, just for the sake of your knowledge, Kendra, you don't have to remember this. Okay, so the total vote of all MLAs of the state will be divided by the total number of elected member of the parliament. It is very common when we are having MLA, it is the total number of elected member in the legislative assembly. When we are having MP, it is total number of elected member of parliament. The only the denominator will be remaining the same, only the upper, that is total population of the state. Here you will be having total value of the votes of all the MLA, and it is already prescribed in the election commission. So just remember this for your knowledge. Next. Now, this is very important and interesting case that you should know. In this case, in re-presidential poll AIR 1974 Supreme Court case, this is. In this case, what happened? Let's go some to the facts of the case. You should know that if you get a legal passage, you can solve the question. I see what we are witnessing from the last 2 years, that Clat, the consortium, is not asking the current legal passages, they are asking the static legal passage. So Hindu Marriage Act, criminal, tort, contract. If you remember Clat 2021, there were around 4 passages on contract. Then this year also, I guess 2 to 3 passages were on contract. At least 2 were there. Then you have Hindu Marriage Act, you have Constitution, you have tort. So Clat is more focused on the static legal knowledge than the current legal knowledge. This does not mean that you have to keep aside the complete current legal knowledge. You have to take into consideration current legal knowledge, but you have to be very focused on your static legal knowledge. So we have already done with tort, we are done with contract, we are done with constitution, almost we are done with the criminal also. Just 1-2 lectures are left that we will cover now, don't worry. So already we are done, we are uploaded also on the YouTube. So go through it very carefully and remember every point of the static legal knowledge. Now this judgment, re-presidential poll AIR 1974, this is also a very important thing that you have to remember. In this, what happened, guys, that during the time of the president election, so when the time of the president election came, the Gujarat assembly was not there. So Gujarat assembly was dissolved. There was no MLA in Gujarat assembly. Okay. In spite of that, the Election Commission of India called for election of the president. There was vacancy in the Gujarat assembly. It was dissolved for some reason or the other. A petition was challenged in the Supreme Court. A petition was filed, that is a public interest litigation was filed, that Your Honor, there is no MLA in the state of Gujarat. The assembly is already dissolved. There is vacancy in the state assembly. So according to the electoral college, we should not go for the election of the president. We should stay the election of the president till the time the Gujarat assembly is having all its MLA. Supreme Court, after having a series of judgment, this is not a direct judgment. Pre-presidential poll is the last judgment, so you don't have to remember all the judgment. When you will be in your law school, you will be getting into consideration all the other judgment. Supreme Court in the last judgment of re-presidential poll held that even if there is a vacancy in the state assembly or even if the assembly is dissolved, that is not a point of view. The election of the president will be held as it is. So tomorrow, if you get a fact that the State Assembly of UP was dissolved because of the President rule, or take the latest example of the Bihar Legislative Assembly has been dissolved because of President rule, and there is election in the month of September of the Vice President of India, for example, then whether the election can be held or not, and you will be given this judgment in the principle, that is the passage. So it will be that Supreme Court has already held that when a vacancy is there in any state assembly or the assembly has been dissolved, it will not restrain the election commission for holding the election of the president. This is also important. Who does not take part in president election? That is the nominated member of the Rajya Sabha, nominated member of the state legislative assembly, members of the legislative council, nominated member of the Union Territory of Delhi and Puducherry. Now, legislative council. Remember this in a bicameral legislature. Can anyone tell me how many states have bicameral legislature? It is 6 or 7. Ankit, confirm me. So we are having 6 to 7 states is having. West Bengal is there, Maharashtra is there, okay, Bihar is there. So the West Bengal has recently introduced the legislative council just in the last year. So whichever state is having bicameral legislature, that legislative council will not going for the vote of the president of India. It is only the legislative assembly which votes for the president election. Am I clear, everyone? Ankit, 6. Everyone, I hope till this everyone, yeah, good. It is 6. Okay. Next slide. Now comes the tenure of the president of India. So we all know that the president holds the office for a period of 5 years, and even after the tenure is over. So for example, on 12th of July 2022, the tenure of Ramnath Kovind ended. Yet till the time Draupadi Murmu took charge as the president of India, he would sit in the office as the president of India till new president is elected. The day Draupadi Murmu will take oath as the president of India and enters the office, from that day Ramnath Kovind ji was not sitting in the Rashtrapati Bhavan. So 5 year term is there, and he will sit in the office even after the completion of the 5 year, given no new election has taken place or no new president has been elected. Now he can resign within this 5 year. He will write a resignation to the Vice President of India. This you have to remember, that whenever the president resigns, he writes to the Vice President of India. Second, and the most famous thing that we all know, is the impeachment of the president under Article 61 of the Indian Constitution. So the president can be impeached under Article 61 of the Constitution, and any resignation that is addressed to the vice president will be communicated to the speaker of the Lok Sabha. So this is another thing. Two important points you have to remember from this slide, that the resignation has to be given to the vice president of India, and the removal of the president is done by the impeachment, that is Article 61. We will have a discussion on impeachment of the president of India. So when can a president be impeached? Okay, generally president are not impeached because they act according to the government. So whichever is the government, the president will act according to the government. Definitely they will sign the bill. But if the government find that the president is going against government find that the president is going against their wishes, they will bring an impeachment in the Lok Sabha, Rajya Sabha. How is the impeachment is introduced? How is the Lok Sabha introduced? How the impeachment is introduced in the Lok Sabha, that we will be discussing. So next slide. Now this is very common thing, that is the qualification. Just have a knowledge. You should have a knowledge. This is a very basic thing you must feel, but you should know that he should be a citizen of India. He has completed the age of 35 years. He is qualified for an election of the member of the House of People. So which is the House of People? Lok Sabha or Rajya Sabha? Lok Sabha. Very good. So Lok Sabha is the House of People. So he should be qualified for the election as a member of the Lok Sabha. Okay. The second point that is mentioned is very important. So because of which I included the slide. I remember a mock of legal age. Okay. A separate passage on office of profit was there in that mock. If you have encountered that mock, Ankit or anyone, there was a separate passage in the legal section on office of profit. What is office of profit? Okay. So you have to understand what is office of profit. Because of which I have included this slide. Because he is a citizen of India, 35 years of age. This is not of much use when you are having this not having such a objective question in your Clat examination. But if you read the second passage, second point, guys, a person shall not be eligible for president election if he holds any office of profit under the government of India or the government of any state or under any local or other authority subject to the control of any said government, which does not include the president, vice president, governor, minister of the union or the state. What is the meaning? So let's have some case laws. So just for your example, previous slide. Have some case laws. It is not mentioned in the slide. I will just listen to me. So Pranab Mukherjee, if you take the example of Pranab Mukherjee, now Pranab Mukherjee was the chairman of some of the authority which was having the control of the government. Okay, so Pranab Mukherjee was the president of India. He is not anymore among us, but he was the president of India, and he was the chairman of a authority of a office which was under the government of India. Okay, which was under the government of India. He stood in the election of the president. He was elected as the president of India. After his being elected as the president of India, his election was challenged. His election was challenged that he holded an office of profit when he filed the nomination. Okay, this was challenged. So in that case, the Supreme Court bench headed by whatever the judge was, it was a 3-judge bench. In that bench stated that the office that Pranab Mukherjee hold did not have a clear-cut influence of the government of India. So there is no need to get a re-election, or the Pranab Mukherjee election was valid. That judgment was a very criticized judgment because in one way or the other, the office was under the government of India. He was getting a certain amount in the form of honorarium from the government of India. So there was a minority judgment. That was not a clear case court judgment. It was a minority judgment who criticized it, which led to the case of Jaya Bachchan versus Union of India. You all know Jaya Bachchan. She is from the UP. So a very famous case of Jaya Bachchan, in which in the UP film board, there is a board for the film city and everything in UP, in which she was the chairman. Okay, she was the chairman. Now, her election was also challenged in a similar manner, that she was holding an office of profit. What Jaya Bachchan argued in the court of law, that although I was the chair, listen very carefully guys, this is the thing that the question was, passage was on in the mock. Although I was holding the office of chairman in the UP film city, I had not taken a single amount of money. I have not taken any salary. They were giving me home, they were giving me other utensils, they were giving me aircraft and a flight ticket and everything. I had not used them. I have even not took any honorarium from them. So, because I have not taken any payment from them, because I have not taken any salary from them, there is no use of any office of profit. Okay? If I would have taken the payment from the UP Film City Board, or if I would have used the whatever facilities they were giving to me, then my election could have been challenged. This was the contention of Jaya Bachchan. However, Supreme Court overruled Jaya Bachchan's contention and stated that, madam, even if you have not taken any salary, if you have not used any facilities of third AC, first AC flight, that is not the point. The point is, if the office that you was holding was a government office, having a control of the government, in one way or the other, that office is having the capacity of giving you a payment. Whether you take the payment or not, that is not an issue. If that office give you a payment of 1 lakh, 2 lakh, 50,000 with different facilities, that office becomes a office of profit and you will be disqualified from the election. So the Supreme Court came with a clear guideline that if there is a government interference in the appointment, removal, if the payment is made by the government, if you are given any facilities by the government, if you work for the government or anything for the public, and if whether it is union government, state government, local authority even, there should be just a control of the government in one way or the other, whether in your appointment, whether in your removal, whether the facilities that is given, it is given by the government, whether you are working for the government, that will come under office of profit under section 58 clause 2, and that's why Jaya Bachchan was told to immediately resign from the UP Film City Board. So this was a very famous landmark judgment that you will be studying in your law school, but you have to remember what is office of profit for the election of president. Is this judgment clear? The Jaya Bachchan's judgment, that what holds actually office of profit? Because I have seen twice or thrice passages on separately on office of profit in the different mocks of Clat 2022. So make sure you, I hope you have understand what is office of profit means. Yeah, thank you, Harshita. Next slide. Now comes a very interesting. So after office of profit, another very important topic that you have to remember is the impeachment of the president. Office of profit is clear to everyone. Very good. Now next we have the impeachment of the president. So first let's read just the provision that is given. Just you can read. I am telling you. We have seen that for the president can be removed from the office by a impeachment, that is under Article 61 of the Constitution. Another thing was the office of profit. So that we discussed in very detail with the Jaya Bachchan case, that if there is office of profit, if as he was holding a office which was having government control, that resulted in office of profit, that president or vice president would be disqualified from his position. They would not be allowed to go for the election of the president. Okay, if it is proved after the election, so for example after Draupadi Murmu is now elected as the president of India, tomorrow if it is proved that she is holding any office of profit in the state of Jharkhand or in the state of Odisha, then she might be asked to resign from either that office or from the post of the president. Another way to remove the president is the impeachment of the president. How does the procedure work for the impeachment of the president? This we have to remember. The first thing that is very clear is the president can only and only be removed from the office for the violation of the constitution. Okay, the president of India can be removed from the office only for the violation of the constitution of India. So any of the provision of the constitution of India, if he or she has violated, there has to be a charge which will be preferred by either house of the parliament. What does this mean? First, let's have an example. Don't go through the slide. It will get, you will get confusion. For example, today is 9th. Yeah, 9th of August. And if Ankit is the MP in Lok Sabha, he wants to bring a impeachment against the president. So if he wants to bring the impeachment on 26th and 10/40, yeah, on 26th of August, on 10th of August, he have to bring a resolution claiming that I am going to bring a charge in which I would be bringing an impeachment against the president, and that resolution has to be given a notice. That resolution, a notice has to be given in 14 days for the resolution that I will be bringing a resolution. That notice has to be signed by not less than 1/4 of the total number of member of the house. Two term makes very important different here when you are solving the legal passage. 1/4 of the total number of members of the house. Second is 1/4 of the total number of members of the house present and voting. If you go according to Article 61, it is only 1/4 of the total number of members of the house. If you mark option B, that is according to 1/4 of the total number of members of the house present and voting, that would be a wrong option. Laws, words are very important game. Okay, the way you interpret a word is very important in law. So first you have to give a notice. Ankit have to give a notice on 10th of August. That is 14 days before the charge. The resolution is brought with 1/4 of the total number of members has to support it. And after 14, giving a 14, after notice, after 14 days, he can bring the resolution for the impeachment of the president for the violation of the constitution. And that resolution has to be passed by a majority of not less than 2/3 of the total membership of the house. Here also you have the total membership of the house. So that is 543 and 250. Lok Sabha, Rajya Sabha, whatever it is. So Ankit brought in, first he will give a notice 14 days before. That notice has to be supported by 1/4 of the total member. And then the resolution will be brought in the house on 26th of August. And that has to be supported by 2/3, not less than 2/3. So 2/3 or more than 2/3 of the total membership of the house. This is the procedure for the impeachment of the president, which charge can be brought in either house of the parliament. For the president, when we will be understanding the vice president, it can be only brought in the council of state, that is Rajya Sabha. For the president, it can be brought either in the Lok Sabha or in the Rajya Sabha. So lower house or upper house, council of state or the house of the people. Next slide. Now, when the Lok Sabha passes this, when the charge that has been preferred by either house of the parliament, after the Lok Sabha passes it with more than two-thirds of the total membership of the house, that charge will be sent to the Rajya Sabha. The Rajya Sabha will investigate the charge. Okay, and after investigation, if that charge is passed by a resolution of more than two-thirds of the total membership of the house, then the president will be impeached from his office on that date. So let's revise very quickly. Charge has to be brought before bringing the charge. A 14 days notice has to be given. Previous slide, Ganesh. A 14 days notice has to be given in advance. That will be signed by not less than 1/4 of the total number of the member of the house, in which they will show that we are having an intention to bring the charge. After 14 days notice, a resolution will be brought in the house, which will be either house, whether it is House of People or Council of State. That resolution has to be passed by two-thirds or more than two-thirds of the total membership of the house. After Lok Sabha or Rajya Sabha, whichever has brought the charge, they have passed it with a majority. It will be sent to the Rajya Sabha. The Rajya Sabha will investigate the charge. After investigation, again there will be a voting. If Rajya Sabha also passes the charge with a vote of more than two-third or more than two-third, the president will be disqualified or impeached. Not disqualified, he will be impeached from his office. Such resolutions shall have the effect of removing the president from his office as from the date on which the resolution is so passed. This words you have to read very carefully when you are solving the legal passages. So this is the process how a president of India is impeached. Clear? Utsav, Ankit, everyone. Utsav has joined also. Good. Okay. Next slide. So this is just summary of things what we have discussed. Lok Sabha initiate an impeachment charge. The impeachment charge are signed by 1/4 of the member of the Lok Sabha. 14 days notice is given to the President of India. Lok Sabha passes the impeachment charges with two-third majority and send it to the Rajya Sabha. Lok Sabha, after signing the charges, passes them the Rajya Sabha toward investigation. Rajya Sabha investigate the charge. While Rajya Sabha investigating the charge, the president has the right to sit in the proceeding. Rajya Sabha agrees to the charge and passes it with two-third majority, and the president stands impeached. This is the summary of what we have discussed. Okay, next. Now comes a very interesting another topic. So we started with very basic things, that how the president of India is elected. That is very important. Electoral college, you have to remember the term elected members and don't get confused with the nominated members. Then we discussed the electoral college. We discussed with the impeachment of the president. Before that, we discussed the office of profit, Jaya Bachchan case and Pranab Mukherjee case. That is also very important. Another very interesting topic that you have to know for the president is the pardoning power of the president. So you will get a separate passage on the pardoning power of the president. If you get a passage, it will be a separate passage. A separate passage with 5 questions can be easily made on the pardoning power of the president. What is the pardoning power of the president? Let's take a very common example. Very common example, not what is written in the slide. So 2012, the whole of the country and even the world witnessed the Nirbhaya gang rape case. So the petition was filed in the district court, then it went to the high court. There was death penalty announced. Some of them were declared minor. Then it came to the Supreme Court. The proceeding went in the Supreme Court for some time, and Supreme Court also ordered that all of them will be executed. So they will be hanged till death. One of them was declared minor, and another one committed suicide in the prison officer, as far I remember. And the other 3 of them was there who were going to be executed. Understand the now what is the thing? Supreme Court in his judgment ordered that the 3 of them for committing rape under Article 376, Section 376 of the IPC, they will be hanged till death. After this, what will happen? So Ankit is the judge. Ankit is the lawyer. Okay, Ankit is the lawyer and Utsav is the judge. So Ankit is the lawyer of the 3 people who have committed the rape, and Kinjla is the lawyer of the girl Nirbhaya and his mother. So the Utsav is the bench. He is leading the bench. He very clearly demarcated that the High Court and the lower court have given a very clear judgment that they should be hanged till death. Ankit said that don't worry, we will be going for a review petition. Listen the words very carefully, guys. You will be getting passages on this. President has become a very important topic for your CLAT examination. Okay. So Ankit will go for a review petition which will be filed in the Supreme Court. There is a limitation for filing the review petition, and he will plead that, Your Honor, my client is the only sole. He is the only person who is the sole earner of my family. He is the only person who is working in my family, and if you will hang my client, his sister is there, his mother is there, his father is there, they will starve to death. Therefore, I plead before you that please convert this death penalty into life imprisonment for 14 years, 10 years, whatever it is. So it is 376. So the minimum punishment is 10 year. Death penalty is the maximum punishment. So this is what Ankit will plead. So Krishna is from the side of the Nirbhaya and her mother. Definitely she will oppose it that no, Your Honor, this is a case which has shook the country, not the country, the whole world in a moving bus. How this person can commit rape? It should bring this. You should give them the death penalty. This will be an example and a precedent for the coming generations. Also, Supreme Court judge, public outside the Supreme Court is definitely there. All are having too much hope from the Supreme Court that we will get the judgment in favor of Nirbhaya. Utsav rejected the review petition. The review petition has been rejected by Utsav. Done. After the review petition will be rejected, the clients of Ankit will go and his father and mother will request him that कुछ कर दो यार, बचा लो इनको, बचा लो, कल को इनके फांसी का सजा है, कल सुबह 6 बजे, है ना, कल सुबह 6 बजे इनकी फांसी का सजा है, बचा लो प्लीज, आप ही कुछ कर सकते हो, आप भगवान हो. अंकित से डोंट वरी, वी विल डू समथिंग. कल सुबह 6 बजे नहीं होता, 4-5 बजे होता है ना, कल सुबह 5 बजे they will be hanged. Today at 4 p.m. Ankit filed a mercy petition to the President of India. Okay guys, that is Article 72 of the Indian Constitution. The power of the President to grant pardon or to suspend, remit, commute sentences in certain cases. Today at 4 p.m. Ankit filed a mercy petition at the President of India that, Your Honor, my client is the sole owner of my family. They are having no criminal antecedent. If you give them a chance, they will definitely improve. I request you to convert the death penalty into life imprisonment or imprisonment for 20 years, 14 years, whatever Ankit will plead. After review petition work is over, President will have the power. What power? First is the suspension. So President will say that, okay, tomorrow 5 a.m. is the execution. I have got it at 5 p.m. Today, let's suspend the execution. This is the first thing that the President can do. ठीक है, कल सुबह 5 बजे execution नहीं होगा. सुप्रीम कोर्ट के रजिस्ट्रार को नोटिस भेज दो, यूनियन कैबिनेट and everything. The secretary will coordinate among themselves. Tomorrow 5 a.m. को तीनों नहीं hanged होंगे, है ना? Commute. What is the meaning of commute? It's the lessening the punishment. So instead of that penalty, ठीक है भाई, they are the sole bread earner of the family. There is no one in the family. There was no criminal antecedent. We will convert the death penalty into life imprisonment. Not imprisonment of 10 year, 20 year. It will be a life imprisonment. So this power has been given to the President, which is known as the pardoning power of the President under Article 72. That the President shall have the power to grant pardon, reprieve, respite, remit punishment or suspend, remit, commute the sentence of any person convicted of any offence in all cases where the punishment is given by the court martial, in all cases where punishment or sentence is for an offence against any law relating to a matter to which the executive power, that is IPC, CRPC is there, in all cases where sentence of death is there. And nothing in this will affect the power of the governor also. So governor is also given the same power under Article 162, pardoning power. This is the whole concept of the pardoning power of the President, which is a very important thing that you people have to understand. Suspend meant the punishment is postponed. Yeah, you will not be executed tomorrow morning. We will check that whether the Supreme Court, what Supreme Court had stated is okay. We will give our judgment now. So now the president cannot go and check that whether the Supreme Court has given a correct judgment or not. This is also a very important question that you might come. So if I will be preparing a legal passage, my first facts will be this: the President of India, newly elected Draupadi Murmu, है ना, might not be having so much knowledge of law. She reviewed the judgment of the Supreme Court and then suspended the death penalty. Whether this is in the eyes of law correct or not? No, this is not correct, because Supreme Court don't the President don't have the power to review the judgment of the Supreme Court. You can grant pardon, you can remit, you can suspend. That is your duty. अगर आपको लगता है कि ऐसा नहीं होना चाहिए, but you cannot review the judgment of the Supreme Court. Okay, next slide. So this is a very famous case of Maru Ram versus Union of India. Very famous case. In the first slide, guys, I told you that the president is just the nominal head of the country. And take the example of the governor. Every day, after every 15 days, there is a big opinion or editorial in the Hindu or Indian Express that the governor is a puppet. And with the appointment, when the appointment of Draupadi Murmu was going on, you must have read some article even related to that, that even Draupadi Murmu is a rubber stamp for the puppet. Supreme Court in the case of Maru Ram versus Union of India stated that under Article 72, the power will be exercised by the Union government, that is central government, not by the president on its own. So the Home Ministry, the Prime Minister, the Council of Ministers will decide that whether pardon should be given to this or not, and they will inform the President. The President will sign. They are bound to act on the aid and advice of the Council of Ministers. Maru Ram versus Union of India, the landmark judgment in the history of the India, that the President is bound to act on the advice of the Council of Ministers, and the President himself or herself cannot decide whether Article 72 she can or he can use. The Supreme Court did not stop there, guys. The Supreme Court came to Ipuru Sudhakar versus Government of Andhra Pradesh, another very landmark judgment in 2006. And it must have come to the mind of Ankit or Kinjla or even Utsav that Supreme, अगर कल President उसका power remit कर देता है या फिर pardon कर देता है या फिर suspend कर देता है, तब तो वो बच जाएगा. Okay? So what will Kinjla do in that case? Kinjla will go for judicial review. That, Your Honor, the President has not applied his mind. The President has acted bona fidely. The decision of the President suffered from arbitration. The consideration that the President took was irrelevant, and therefore, Your Honor, immediately struck down the suspension, immediately struck down the remission that the President of India gave. So directly we did not went to Ipuru Sudhakar versus Government of Andhra Pradesh. There was a series of cases that you will be learning in your law school, guys. You have to remember just this, that once the President do this, even after that, that mercy petition can be challenged again in the Supreme Court by Kinjla, that Your Honor, on foreground, first there was no application of mind. So the Home Ministry saw that ठीक है यार, कर देते ना, काम क्या हो जाएगा, ऐसा क्या है. The Home Ministry has to study in detail. It has to discuss with the minister. It has to discuss with the law minister, with the law secretary, and then only the Home Ministry can lessen the punishment or suspend the execution. Bona fide. Home Minister, he is having some relation with the Finance Minister, with the Home Minister, with the law secretary. Intention should be bona fide, not malafide. It should not suffer from arbitrariness. So the Home Ministry itself kept the file for 7 years. We are having landmark judgment on these things. That it took 7 years for the President of India to grant pardon to take a file of death penalty. The Union Home Minister kept the file with himself for 7 years. After which they passed it to the President. The President signed it and returned back to the mercy petition was rejected. This was challenged in the Supreme Court, that it suffered from arbitrariness. Irrelevant consideration was taken into. Ankit told that he is the sole bread earner of the family. When it was considered, when it was checked, the father was earning lakh of rupees. There was another brother who was earning 50,000. The sister was earning 20,000. No sole breadwinner of the family he was. Or any other consideration that the Home Ministry or the President took into consideration was irrelevant. India will bring the petition under judicial review. That the mercy petition granted by the President will go for the judicial review and the Supreme Court has to accept it. Before which 2006 the case was that the judicial review cannot be done of the President mercy petition. But finally we had this Ipuru Sudhakar versus Government of Andhra Pradesh, and as a law aspirant, you should be very clear that definitely we should have a judicial review of the mercy petition. So this two landmark judgment you have to remember what is the thing. Next slide. Then we have the legislative function. This is very common thing that as we all know that the Lok Sabha, the Parliament should meet twice a year. Generally we meet thrice a year: monsoon session, winter session, budget session. But it is the duty of the President to summon the House of Parliament at least twice a year or prorogue the House. Whenever it is a general election, after every general election, it is the President who will give the opening statement. It is the President who can call for joint session of both House of the Parliament. When a joint session of both House of the Parliament is called, when there is a deadlock on a bill. So in Lok Sabha, the present NDA government is having majority. They brought the bill on population control. The bill was passed by the Lok Sabha. It was sent to the Rajya Sabha. The BJP government or the NDA government is not having seats in the Rajya Sabha. The bill elapsed in the Rajya Sabha. The President on this will summon both the House of the Parliament for a joint session of both House of the Parliament, that Lok Sabha, Rajya Sabha will sit together and they will solve the dispute, the deadlock. Who will preside Utsav over the joint session of both House of Parliament? Anyone? Utsav, Ankit, Ashita. Who will preside over the joint session of both House of the Parliament? No, not the President. How can a President preside over the joint session? Who preside over the Lok Sabha? Lok Sabha is presided by whom? Tell me, guys. Don't feel anything. It is wrong or right. Don't feel anything. Speaker. For the Rajya Sabha, we are having the who presides over the Rajya Sabha? Vice President. That is called the chairman. There he is called the chairman. When it is a joint session of both House of the Parliament, we are having the Speaker of the Lok Sabha who will preside over the joint session of both House of the Parliament. So they will sit together, they will solve the dispute, the deadlock will be solved. The Union Ministry of Women and Child, the Health Ministry, Mansukh Mandavia and Smriti Irani will inform and the House that why there is a need for population bill. Then again the vote will be there and then the bill will pass or bill will fail accordingly. That session will be presided over by the Speaker, but it will be summoned by the President. Guys, this is not only important for Clat. This is as a law student, even as a layman, a person preparing for SSC, bank, railway, UPSC, JPSC, BPSC, judiciary should always, for your whole lifetime, you should remember these things. It is not only relevant for Clat only. Okay. So it is the President who can summon the House, who can dissolve the Lok Sabha. Now, if the Prime Minister tomorrow, Narendra Modi, feel that I am not having the support or I am not having the majority in the House, he will ask the President, कि भैया आप dissolve कर दो लोक सभा को, we will have a fresh election. So it is the President who can dissolve the Lok Sabha. It is the President who will call for the joint session of both House of the Parliament. It is the President who, at the commencement of every session, he deliver an address. So this is the legislative function of the President. Next slide. Then the same thing, he nominates 12 members to the Rajya Sabha. He appoints Speaker, Deputy Speaker, Chairman of the Rajya Sabha. Every bill passed by the Parliament must receive the President's assent before the bill becomes an act. The President may give his assent or withhold his assent, return it for reconsideration by the Parliament when it is not a money bill. Next slide, we will be understanding this thing in detail what it is, guys. Only and only when it is a money bill, the President is bound to accept and sign the bill, assent the bill. Because what is the reason for this? Because a money bill is introduced by the President after having a discussion with the President. Only the money bill is introduced in the Lok Sabha. Okay. So except for the money bill, the president can send back any bill for reconsideration to the house. Until and unless a bills receive the president assent, it will not become an act. So the bill is passed by the Lok Sabha, the bill is passed by the Rajya Sabha, but till the time it receives the assent of the president, it is called a bill. The moment it will receive the assent of the president, it will become an act. Next slide. So the president has what all option with him when now, for example, you are having a bill is passed by the Lok Sabha, Rajya Sabha, it is presented to the parliament. Okay, the president will be giving an assent. He will giving his assent immediately. कि ठीक है, I am the president and the Ramnath Kovind for us the president. Citizenship amendment bill is passed, farm bill is passed. I will give the assent. So he gives the assent. Second thing is that he will withhold his assent. So he will withhold his assent for 6 months, 8 months. For 6 months, 8 months, he will keep on not giving the assent. Giving a very good example for the second point that is mentioned, Tamil Nadu. So if you remember, the case of Tamil Nadu is trying from the last 5 to 7 years to scrap the NEET examination. है ना? Now this year after election, when the new government was formed, the government after the formation, they brought a bill that we will be scrapping the NET and we will having a different examination here for the state of Tamil Nadu. The bill was passed by the State Legislative Assembly of Tamil Nadu and it was presented to the governor of Tamil Nadu. The governor did not sign the bill. The governor did not sign the bill. He withheld his assent on the bill. Now, nowhere in the Indian Constitution it is mentioned, guys, first point, that within what time the president or the governor has to sign the bill. So, I will sit on the bill. I will go to Goa, I will go to Daman, I will go to Diu, I will go to Chennai and I will go to America. I will enjoy my whole 5 year and keep the bill as it is. That is the withholding of the bill, because nowhere it is mentioned in the Constitution that within this time the governor has to sign the bill. That what did the governor of Tamil Nadu did. And even we have no precedence by the Supreme Court yet. And the second most important thing is the governor and the president is not answerable to any court of law under Article 361. During their tenure, whatever activity they do, they are not answerable to the court of the law. So governor is sitting very and having his all his work. Let the Tamil Nadu bill let it be there. Let us share the screen. Okay. So the president will keep the bill withholding with himself. He will sign it. The first option that the president have, that he will sign the bill immediately. He will give assent to the bill. I hope I am audible to you people. Ankit, there might. It is okay. So the president will sign the bill immediately. Okay, or he will withhold the bill, that I will not sign the. I will not give my assent to the bill. The third option that the president have is that he will be sending the bill back for reconsideration. Okay, so if the president feels that this bill is not according to the objective of the constitution, it is against the Indian constitution, it's violate the Indian constitution, the president will be sending back the bill to the Lok Sabha or the parliament, that you people have to reconsider this bill. Once the president sent back the bill for reconsideration and the parliament after reconsideration send it back to the president, for no more time the president can send it back. He have to or she has to give the assent of the bill. So this is the veto power of the president, which is called the absolute veto, where he will be sitting with the bill. Suspensive veto, he will be sending it back. Pocket veto is where he will be reconsideration will be there, and then he will be asking them to reconsider the bill and send it back, and then he will sign the bill. This is the third option that the president has. So these are the three things that the president can do when he gets a bill for signing, that he will sign it immediately, he will withhold the bill, he will send it bill for the reconsideration, but you have to remember that should not be a money bill. Okay, next slide. Another very interesting topic that you should know is the ordinance making power of the president. A very, very arbitrarily used power that every government, whether it is the present government, previous government, uses. There has to be some limit for the ordinance making power of the president. However, constitutionally it has been approved. The ordinance making power is correct. So this is another legislative power that the president have. What is the criteria, guys? That when the parliament is not in house, the house is not in session. If you remember the triple talaq. So triple talaq we had first an ordinance. It was then when the house came into session, it was presented and then it was passed. Similarly, the recent we had one epidemic related ordinance was also brought. So what is the criteria for ordinance? When you can bring an ordinance? The president or the governor can bring an ordinance. The first criteria is that the house is not in session. So the Lok Sabha, Rajya Sabha, State Legislative Assembly is not in session. Then you can bring an ordinance. But it should be a need of the hour. This term has been widely misused by the present government, by the previous government, and every government misused this term because ordinance is only brought when when it is the need of the hour. It is not for everyday purpose. If you remember, some articles were there when we were having Clat 2022 preparation. Every day, I remember for a week, continuous week in Hindu and Indian Express, we got an article on the abuse of the ordinance making power of the president, how the government is abusing the ordinance making power of the government, because the criteria is that the house is not in session. That is a very common criteria, but it should be the need of the hour, that why you are bringing the session. What was the need to bring an ordinance for triple talaq? If we take practically, don't think as a layman or as a just from the pro government or against the government. Think as a law student that there was no need of bringing an triple talaq ordinance. Definitely, after 1 month, the house was there in the session. You could bring a law, you could get it passed. Anyway, without going in all this political activities, ordinance making power is Article 123. When the recommendation of the Union Cabinet, that is Prime Minister and the Union Cabinet Minister, the President will sign an ordinance, and that ordinance has to be brought within 6 weeks of the session. When the house is session, within 6 weeks you have to bring that ordinance into the house and get it passed. If it is not, then the ordinance will elapse. There the Supreme Court came with a very famous case of DC Wadhwa and other versus State of Bihar, where the Supreme Court stated that when the line of the constitution is crossed by the ordinance, it will come into judicial review. Until then, not. So only and only if the provision of the constitution is violated, the limit of the constitution has been crossed by the ordinance, only then there will be a judicial review of the ordinance that was brought by the government of India, by the president. If there is no violation of the provision of the constitution, if the limit of the constitution has not been violated, there will be no judicial review of the ordinance that was brought by the president of India. So this is the ordinance making power of the president. It is very important also for you to know about what is ordinance making power of the president, when it can be introduced, within what time it has to be passed by the both house of the parliament, and whether it is subjected to judicial review or not. I hope it is clear till this, everyone, guys. Okay, good. Next slide. Then we come to the another interesting. So you must be thinking that सारे topic में भैया interesting ही बोलते हैं. For every topic is interesting when you do take it into consideration from the law point of view, and this is itself a very interesting topic. So we are having 3 type of emergency, that is the extraordinary power of the president. First is Article 352, that is national emergency. 356 president rule, and financial emergency Article 360. नीचे से ऊपर जाते हैं, है ना? We will go for first financial, then national, then we will come president, because it is an interesting thing. Financial emergency has not been imposed in India for events. 1, twice or thrice we were in the process of having a financial emergency, but we did not have any financial emergency. What is financial emergency? Now, financial emergency, as the name itself suggests, that the GDP of the country is not stable, inflation is there, demand supply balance is not there, the country could not meet its expenses. And taking the example of which country, guys, recent, let me see how much current affairs people are studying for Clat 2023. Very good Ankit, very good Kinila, good, yeah guys, very good. So I don't need to explain any more to you the financial emergency, Sri Lanka. So the condition of the country was such, leave apart petrol, leave apart the expensive things, you could not have the rice, You cannot have the amount to procure wheat. You cannot have the amount to procure oil, edible oil, leave the petroleum product and everything. You don't have the amount to buy milk and milk products. Who is the president of Sri Lanka? Present president. Spelling might be wrong. That is not an issue. But just who is the president of India? The present president of India, guys. Ah, very good. Ranil Wickremesinghe. Yeah, Ranil Wickremesinghe is the president of India. Sorry, president of Sri Lanka. Yeah. Okay, Ankit, good. I was talking about president of Sri Lanka. That is Ranil Wickremesinghe. President of India is Draupadi Murmu. I was talking about president of Sri Lanka. Yeah, Wickremesinghe. Yeah, Ranil Wickremesinghe. So financial emergency was declared in the in the country of Sri Lanka. That is financial emergency. It has not been imposed in India. Okay, India president in India's president is Draupadi Murmu. Okay, sorry for the confusion. First, then is the national emergency. So 1975. Whenever the term national emergency comes, it comes to our mind the 1975 era when the national emergency was imposed, a very black day in the history of India. Okay, so national emergency is something when there is an external aggression, whether we have internal rebellion or armed rebellion. Anyone? I think Utsav will answer the correct answer. Whether we have internal rebellion or armed rebellion in country. Very good, Kindla. Okay, good, very good. So we are now having armed rebellion. Why did this come? Because 1975, the then Prime Minister of India and then President in 1975 imposed national emergency in India on the condition of, very good, armed with 44 amendment. Good. So they brought that we are having an external aggression and we are having an internal aggression also, and therefore we are imposing emergency. This was substituted by the 44th amendment with armed rebellion. So it is a national. The country is not in a good position to have a deal with its neighbor. There is an external China on the one side, America on the one, then Pakistan with China, or any country, whichever it is, not any particular country. So we are not in a good position. Then we will be having the national emergency on the ground of external aggression in armed rebellion. So that is the national emergency. The very interesting topic is the president rule. So today Chirag Paswan, just 2.5 hours before, came on the Twitter after a very long period of 2.5 years and told that I request the Union Cabinet and the President and the Prime Minister to impose president rule in Bihar. Did you people saw the news of Bihar recent political turmoil? I hope you must. Ankit. So there is a split. There is, and the government has been dissolved. NDA and JDU has been splitted, and they are going to form another government with RJD. Whatever it is, that is political thing. But Chirag Paswan demand क्या कर रहे हैं? President rule लगा दीजिए, president rule लगा दीजिए. This is not an acceptable thing. We cannot impose president rule in such circumstances. Definitely. Now Ankit is the lawyer of Chirag Paswan, and he tells that अरे president rule लग जाएगा ना, कितना अच्छा रहेगा. There will be fresh election. Ankit says, no sir, I am a lawyer. I have studied from Nalsar. So you must be thinking, Ankit, that why bhaiya don't tell Bangalore. So Nalsar is good. So I have studied from Nalsar. I have studied from Kolkata. I have studied from Jodhpur. I know law more than you, na man. This is not a criteria for president rule. When is a president rule imposed in the state? When there is a breakdown of the constitutional machinery. So when the constitutional machinery of the state fails, the government of that particular state is not working according to the constitution, that time the president rule is imposed, and it is the most common thing used by the government of India, or whichever government it is, that is used by the president. That is the president rule, which is imposed in various states of India. The latest, if we remember, Jammu Kashmir, after which Article 370 was scrapped on 5th of August 2019. So president rule is the meaning is that the president will having the power to run that particular state. Every decision will be taken in the name of the president. There will be no government. And after some time, 6 months or whatever duration, the election commission will notify fresh election, which is called as mid-term election or by-election. The mid-term election or by-election will be conducted, and then a new government will form. By that time, there will be president rule in that particular state. If you remember, after the post-poll violence of West Bengal, you guys must remember that when the new government of Mamata Banerjee was formed, then there was post-poll violence and everyone was demanding that there should be president rule. That was a scenario when president rule could have been imposed by the government of India. The government of India did not, that we are not going to discuss on all that issue, but that was the circumstances when there was a constitutional breakdown machinery, the constitutional machinery of the state was in breakdown. The government was not working according to the constitution, and that was the case of president rule. If that time president rule could have been invoked, then Ankit would have won the case in Supreme Court. But if Ankit would go on the words of Chirag Paswan and impose president rule in Bihar and demand Narendra Modi to impose president rule, and if president rule is imposed and Ankit will defend the president rule, Ankit will lose because we are not having a constitutional breakdown. RJD and all the other party, the opposition who were in the opposition, they are having the number, the majority number to form the government. So that is not a constitutional breakdown. In case none of the party could have a majority to, even after forming a coalition, that time the president rule could have been imposed. Clear, guys? Emergency power, national emergency, president rule, financial emergency. These are very three important things that you have to remember. Next slide. Then is the financial power of the president. So any money bill can be introduced in the Lok Sabha only and only on the recommendation of the president. It is the president whose assent is required for any kind of demand, and it is the president who constitutes the finance commission after every 5 years. So this is the president financial power that has been vested by the Constitution of India. Not much of your relevance. Next slide. Then we come to the immunities of the president. So as I was discussing in one of the previous slides, that the president and the governor is not answerable to any court of law during their tenure. You cannot start any criminal proceeding against the president when he is in office. On now, Ramnath Kovind, if any criminal proceeding is started against Ramnath Kovind, that is okay. Then you cannot challenge it. Okay, so Ankit is an emerging lawyer and he feels that अरे रामनाथ कोविंद के ऊपर केस हो गया है, मैं डिफेंड करता हूँ. जाके उसने रामनाथ कोविंद को बोल दिया कि you are having immunity under Article 361 of the Indian Constitution. Don't worry, I will save you. Supreme Court will go and tell. Supreme Court will tell that go and read it very carefully, because it is only for the time when you are having in the tenure of your office. No criminal proceeding can be instituted against the president, governor, Rajapaksha. Now we don't have Rajapaksha. He cannot be arrested. The president of India cannot be arrested. It is very important point, guys. He is not answerable to any court of law for the activities of duties and power of his office. So whatever activities he is doing in his office, he is not answerable for that to the court of law. You cannot ask the president, you cannot summon the president. So kal Utsav will be becoming the judge for Bangalore or New Delhi judiciary nikal ke he is becoming the magistrate or the civil judge, and he will summon the president. Yeah, ye jawab dijiye. Next day there will be impeachment of Utsav itself. Okay, so you cannot ask the president to answer in court of law. You cannot arrest the president. You cannot bring up criminal proceeding against the president of India. This is the immunity that is given to the president of India under Article 361 to the governor also. Okay, next slide. So this is the president or the governor or the Rajapaksa of the state shall not be answerable to any court for the exercise and performance of the power or the duty for any act done or purporting to be done by him in exercise and performance of those power and duties, provided that the conduct of the president may be brought under review by any court appointed designated by either House of Parliament for investigation only and only under Article 61. No criminal proceeding whatsoever shall be instituted or continued against the president or the governor in any court during his term of office. No process for the arrest or imprisonment of the president or the governor of the state shall issue from any court during his term of office, but only his term of office. Guys, this is an important term. Aaj Ramnath Kovind tenure is over. Tomorrow, Kimila has brought a case against him. That is okay. So this is the protection that is given to the president and the governor before we have the Raj Prabhu and everything. Next slide. Now answer this question, guys. Immediately we will start with Vice President. First President of India. Quick. First President of India. First woman President of India. Present President of India. Rajendra Prasad. First President of India. First woman President of India. And first tribal and woman President of India. Present President of India is also the same. Pratibha Patil, Bird, Draupadi Murmu. Present President and the first tribal and women. Okay, good. So we are done with the President of India, starting with the Vice President. It is very short. Everything is similar to the President. Some small changes are there when we talk about Vice President. So let's start with
Aryan,
the
I have a
Vice President.
question.
Yeah.
What if a president commits a crime? Then he or she immune under Article 356?
Under article?
The Article 351, I guess,
No,
the one
361.
which provides
361.
361, Article
Huh.
361.
So yeah, Ganesh, previous slide. 361 clause 2. No criminal proceeding whatsoever shall be instituted or constituted against the president or the governor in any court during his term of office. So if the president commits murder, if the president commits theft, if he commits extortion, robbery, any of the offense under Indian Penal Code which is a criminal offense, no proceeding will be instituted when he is in term of office Utsav. The moment he will be out of his office, Pinjla will bring a case that he has committed on such date and such day in that year a murder, a theft, a robbery, a extortion. Very good question. The same question I also asked to my professor when he was teaching us this topic. Okay, so this clear? Oh, okay. Any point of time, if you have any doubt, let me know, guys. Okay, so we are done with the president. Now coming to the vice president of India, it is very short. Not nothing much we have to do there. So Article 63 talks that there shall be vice president of India. This is important. The Vice President of India will be the ex officio chairman of the Council of State and shall not hold any office of profit. So, office of profit we have already discussed. That is the Jaya Bachchan case, Pranab Mukherjee case. That what is an office of profit? He will be the ex officio chairman of the Council of State. So, he is the chairman. Now we will be having who will be the new chairman of Council of State? Guys, who is the new chairman? So, Venkaiah Naidu is has already his tenure is over. Jagdeep Dhankar. Who was Jagdeep Dhankar? Who was Jagdeep Dhankar before this? Before President of India, Governor of West Bengal, and who is the present Governor of West Bengal? Now, during any period when the Vice President act as the President, when he will be acting as the Vice President, we will be discussing in the next slide. When the Vice President act as the President under Article 65, at that point of time, he will not perform the duty of the Chairman of the Council of State, and he will not be getting any payment for the Chairman that he was getting. This is clear. Okay, so he is the ex officio chairman. Guys, who is the present governor of West Bengal? But when he is acting as the president, when the vice president is acting as the president, he will not act as the chairman of the Council of State and he will not be entitled to any salary or allowance during that time. Okay, next slide. So the vice president to act as president or discharge his function during casual vacancy in the office. Now, first is the president. There is a death of the president. The president has resigned. The president has been removed by the case of impeachment or disqualified. In that case, it is the vice president. He will act as the president until the date on which a new president is elected. Generally, it is 6 months. So within 6 months, the next president has to be elected. And the thing is that when the vice president is acting as a president, he will be getting all the immunities and he will be having all the power that the president had when as a president. Sri La Ganeshan. Very good, Utsav. You have to remember, guys, this is a very important thing that you should know. La Ganeshan is the president, governor of West Bengal. So even in case, not only in case of death, or not even in case of resignation, removal, or otherwise, even when he is ill, when he is for any other reason, he is out of country, he is absent. For example, the president Draupadi Murmu has went to Sri Lanka for a new. We will have a new meeting with Sri Lanka. We will develop the things there. At that point of time, there is a financial emergency in the country. So he has went for a trip of 10 days. He is not here. There is a financial emergency in the country. It is the Vice President of India, that is Sri Jagdeep Dhankar ji. He will assume the responsibility of the President of India and take the decision accordingly. At that particular point of time, he will not be the chairman of the Rajya Sabha. Plus, he will be getting all the benefits, salaries, immunities that the president had. all the alliance, all the privileges. So this is the vice president acting as the president. Next. Now, election of the vice president is similar to that of the president, where we are having an indirect election. But the difference is that here the both houses of the parliament will only be there. The vice president will not be elected by a legislative assembly. So when there is no legislative assembly, it excludes Delhi and Puducherry itself. Because in the president, when we had the legislative assembly of the state, we had Puducherry and New Delhi. But when the vice president is elected by an electoral college which is having only both houses of the parliament in the system of proportional representation and everything, we do not have the state legislative assembly, which means we do not have Delhi and Puducherry in the electoral college. Okay, and then we have the president should not be a member of the president should be having the qualification of being elected as the member of House of Parliament. But we as a vice president is that the vice president should not be member of either House of Parliament or House of the Legislature. And if this is very important, and if a member of either House of Parliament or of a House of Legislature of any state be elected vice president, he shall be deemed to have vacated his seat in the House on the date on which he entered upon his office as the vice president. So Jagdeep Dhankar is very clear. He was the governor of West Bengal, not an issue. Remember M. Venkaiah Naidu. Venkaiah Naidu was a member of the Rajya Sabha or Lok Sabha. I don't remember specifically, but he was a member of either House of the Parliament. The day he became the vice president of India, he automatically he vacated his seat on that particular house on that date. So he should not be a member of either House of the Parliament, Lok Sabha, Rajya Sabha, or the state legislature even. The moment he will be becoming vice president, if he was so, he have to vacate that particular post. Next. Again the same thing, he is a citizen of India, 35 years of age, is qualified for election of a member of Council of State. So for the president, we have that is qualified for election as a member of the House of People, that is the Lok Sabha. For the vice president, he should be qualified for election as a member of the Rajya Sabha, and a person shall not be eligible for election of vice president if he holds any office of profit. We have already had a good discussion on what is office of profit with Jaya Bachchan case. So this is the vice president qualification. Next. Now this is interesting thing, that is matter pertaining to the election of the president or vice president. What is the law? The according to the constitution of India, the thing is that uh, if there is a dispute arising out of the election of the president, or if there is any doubt with the election of the president, whether there is a procedure elapse or whether there is anything, it will be inquired and decided only and only by the Supreme Court of India, whose decision will be final. So, for example, if tomorrow we already had the election of the Draupadi Murmu, we had the election of Jagdeep Dhankar. Tomorrow, if anyone challenges the election of Draupadi Murmu on the ground that he was holding any office of profit in the state of Jharkhand, in the state of Odisha, or Jagdeep Dhankar election is not correct, not the procedure is not followed, then it is not the speaker who will sit and decide that whether the election is correct or not. It is not Narendra Modi. It is not the it is not the deputy chairman of the Rajya Sabha. It is only and only the Supreme Court of India, not the magistrate, not district court, high court. It is only and only the Supreme Court who will inquire and decide the petition for challenging the election of the president and vice president. Now, this does not mean that any decision that has been taken by Draupadi Murmu or Jagdeep Dhankar during that tenure will become void. No, the Supreme Court will not invalidate the decision of Jagdeep Dhankar or Draupadi Murmu if their election is challenged tomorrow. Whatever decision they took, it will be considered as it is. Any decision that they have taken, that will not be declared as void. Any duties that they have performed will be as it is. Only they will be removed if it is proved that the election was not correct, the correct procedure was not followed. In that case, they will be removed from the as the president, and the person who challenged that petition, if he has demanded that I am the correct person who should be elected as the president, so tomorrow if Yashwant Sinha goes and says that I am the correct person that I should be elected as the president, then if after inquiring into it, the Supreme Court will inquire into the matter, then it will be done that it is Yashwant Sinha who should be the president and not Draupadi Murmu. So any matter relating to or connected with the election of the president dispute will be inquired by the Supreme Court itself. Okay, yeah. Next. Next slide. Yeah. Then the removal of the president. So we read, guys, that for the removal of the president of India, the resolution can be initiated in either house of the parliament. But when we have the removal of the vice president of India, the it can be brought only and only, the resolution can be initiated only and only in the Council of State. Again, the same procedure that we have discussed previously will be followed. That there will be a notice of 14 days notice has to be given. One fourth of the member will be supporting by writing it in written, by signing it. Then the resolution will be initiated in the Council of State, that is Rajya Sabha. After which it will go to the Lok Sabha. There they will be inquiring into it, and then it get passed. And then the president or the vice president will be removed accordingly. Here we are having the vice president. So vice president will be removed. The only difference is that for the president it can be initiated in either house of the parliament, but when we are having the vice president, it can be introduced only and only in the Rajya Sabha, that is the Council of State. Okay, next. So this is very similar to what we have already discussed. So it will not take. It's already completed, I feel. So let me know, guys, who is the first vice president of India and the current vice president of India, and then we will done with this session. First vice president of India and current vice president of India. Fast, fast, fast. Even if you're not getting first vice president, let me know the current vice president, S. Radhakrishnan. Actually, it takes time to type his name so that the spelling mistake is not there. So, S. Radhakrishnan was the first vice president of India, and who is the current vice president? That is Jagdeep Dhamkar. So, for election, from what is the qualification to be a president of India, how he is elected, what are his power, financial emergency, national emergency, ordinance making power, how he is impeached, what his power to grant pardon, his mercy petition, and then the vice president having the same thing. This is all that you have to remember for a president and vice president in India. That is from all from my side, guys. Thank you.